Good morning. I'm Ken Paulson. I'm the president of the First Amendment Center. I'm delighted to welcome you to the Newseum and the First Amendment Center. We have offices here at the Newseum and also at Vanderbilt University in Nashville. This is the 15th annual such event, and we're very proud of it. It goes to the core of what we do. As you know from the plaque outside, 74 foot high and blazoned with the 45 words of the First Amendment. We take the First Amendment very seriously here. But, you know, so many people miss the point that without the free flow of information, freedom of the press is truly meaningless. And that's why today is so important. I'm struck that if this were a gathering of the Second Amendment, it would be akin to saying the Second Amendment would be meaningless without bullets. Our ammunition comes from information, and largely government information, and that's why it's so critical to keep a close eye on what's going on. I am curious about something because I see so many fresh faces in the room. How many of you know or have met or are aware of Paul McMasters? Okay, that's interesting, about half the room. We would not be here today without Paul McMasters, who 15 years ago organized the first such event and fueled it and organized it for many years. And then, to our amazement, he retired, and he sort of stayed retired. Isn't that just, I keep waiting for him to come bursting through the door and outraged about something. Those of you who don't know Paul, just you should Google him. Although I'm not sure what you will find. But he is truly the founder of this event, and I wanted to acknowledge his contributions. And when he left, the question was, how do you maintain the quality of it? And the answer turns out to be Gene Policinski, Senior Vice President of the First Amendment Center, who is a master organizer, more significantly a master cajoler, and a true champion of FOI. And you will hear from him in a moment, but we do thank him for his extraordinary efforts here. We've had the good fortune of having many fine organizations partner with us on this, including the American Library Association, the Reporters Committee for Freedom of the Press, the American Society of News Editors, and particularly in recent years, openthegovernment.org. And I'd like to introduce Patrice McDermott, the Executive Director, and our truly valuable programming partner, Patrice McDermott.
A little different order than we had originally planned.
Patrice, this is just a welcome.
Oh, okay, good. Thank you. Thank you. So, yes. Thank you. I was preparing to launch into my 10-minute later talk. Welcome, everybody, and we so much appreciate your coming out this morning. This culmination of Sunshine Week for the weekday events. My coalition is, or openthegovernment.org, is a coalition of about 80-plus organizations. About half of them are based in the states, and we work to promote openness in government and push back, more importantly, secrecy in government. And we are very pleased to be partnering with Freedom Forum, the First Amendment Foundation, First Amendment Center, and Gene Policinski this morning to put on this event. We're very pleased to have a mix of people from our openness community and people from government here to talk about moving open government forward. And I'm going to now turn it over to Gene to get the day going.
Thank you very much, Patrice. Thank you. Good morning. And as always, we caught you in mid-bite there. I'm so sorry. But it's good to have you here. I see people from previous years, and I know that we have some new people with us. So let me briefly talk about this day. Ken touched on the heritage of this and the 15 years that we've been doing it. One of the hallmarks of the First Amendment Center, of the Newseum, the Freedom Forum, and this event is that it is, to some degree, a safe harbor, although we have vigorous discussions within that harbor. But this is a chance for us to exchange views, that this is not just preaching to one choir or the other. A hallmark of FOI Day, as Patrice mentioned, is that we have people from all dimensions of the corners and circle of freedom of information that We hope that there'll be a free flow of information today. There will be a Q&A after, I think, every single presentation throughout the day and within each group. And I'll be the ringmaster today. So follow me as best we can, and I'll follow Patrice, and then we'll be okay. Indefatigable is the word for openthegovernment.org and Patrice, who have helped organize these sessions, particularly this morning. And then I would point out in the afternoon we have posters today. We have Floyd Abrams, the noted First Amendment attorney, talking to with Ron Collins, who has just written a book about Floyd called Nuanced Absolutism. And there'll be actually a moderated discussion with Tony Morrow, who's the Supreme Court correspondent for the First Amendment Center and for American Lawyer, and has been covering the court for a number of years. And then we'll actually take the first look ever at some clips from a new documentary, War on Whistleblowers, and we'll be joined there by the producer and by a reporter from USA Today who is in the video, but also was responsible for a number of stories about the Pentagon, and it'll be a really vibrant discussion. So I hope we'll be with us throughout the day. And this year, we vary the order for those of you who've been here before a little bit. Typically at the midday, we have our partners, the American Library Association, announcing the James Madison Award. That's particularly appropriate for here since we're gathered on this day, one day in advance of James Madison's birthday, but National FOI Day does take place each year on or about President Madison's birthday, as the author of the First Amendment. So if I may, then we'll move to the next part of the program and introduce Maureen Sullivan, who is president of the American Library Association, for the presentation of the James Madison Award.
Thank you and good morning. On behalf of the American Library Association, I also welcome all of you to the 15th Annual Freedom of Information Day, a very special event that brings together advocates, librarians, government officials, lawyers, journalists, and educators. Over the past few decades, many people in this room have fought hard to protect and promote the public's right to know. As we commemorate James Madison's 262nd birthday, we look forward to the day when we will no longer have to fight for the public access to government information. Today, we are here to honor, celebrate, and recognize individuals who have championed, protected, and promoted public access to government information and the public's right to know. The James Madison Award is named for President James Madison and was established by members of the Coalition on Government Information in 1989. This year, we received the Madison Award nomination letters from people across the country. One of those letter writers was Congressman Zoe Lofgren, a longtime public advocate and supporter of access to government information. We were very pleased to receive the letter from the Congresswoman, since she received the Madison Award last year for her advocacy leadership. ALA and our nation's libraries are very proud of the work that Congresswoman Lofgren has done to make research and government information more available to the public. Congresswoman Lofgren fought tirelessly to oppose the Stop Online Piracy Act, the intrusive bill that would have required Internet service providers to police user activities. Lofgren advocated against the bill, and she foresaw the potential harm that SOPA could have had on First Amendment rights, intellectual freedom, and privacy. Most recently, Congresswoman Lofgren co-sponsored the Fair Access to Science and Technology Research Act, a bill that would require public access to taxpayer-funded research. This year, Lofgren introduced Aaron's Law to Congress. The legislation is intended to reform the Computer Fraud and Abuse Act. The Congresswoman would have loved to have been here with us this morning. She had to cancel at the last minute because of an emergency. The Congresswoman did prepare remarks about this year's honoree that she would like me to read aloud this morning, and that is what I will do. I am now going to read to you the remarks prepared by Congresswoman Lofgren. My apologies for not being able to be with you today to pay tribute to a young man who was an outspoken advocate for the public's right to know, and whose voice was tragically silenced too soon. It was a great honor to accept the 2012 James Madison Award last year, and I had looked forward to participating in today's ceremony honoring Aaron Swartz. Aaron knew how important the Internet is to a platform for open communication and access to information. From an early age, Aaron made significant contributions to free speech and technology. As a brilliant prodigy, he helped develop the web feed format RSS, the Creative Commons, and the social news and information site Reddit. Each of these achievements was geared toward making information easily available to anyone who wants it. Those achievements helped drive him to protect and promote the public's right to know. He founded the group Demand Progress as a vehicle for his activism in favor of online free expression and against censorship of the Internet. This activism was crucial in the fight to stop SOFA. Aaron worked to break down barriers to the public's right to know. It was Aaron who opened up the complete bibliographic data for books held by the Library of Congress, making this information free on the open library. He did the same with PACER, a federal court website that charges the public to access court records, all of which are public records and free of copyright. To Aaron, PACER action was a civil act to alert the public and pressure the government about the growing problem of restricting open access to public information. When I read about Aaron's passing, and as the details of the prosecution against him became more publicly known, I was outraged. It made me think about Dr. Martin Luther King, Jr. and his time in the Birmingham jail. When you commit an act of civil disobedience, you do so with the knowledge that you could be punished. In Dr. King's case, it was 11 days in jail. Aaron faced 13 felony charges with the possibility of 35 years in prison. It's appropriate that we honor Aaron today with the 2013 James Madison Award. We should also recommit ourselves to a bedrock principle that goes back to our country's founding. That is why we have a free press, a national postal system, public libraries, and publicly supported educational opportunities that are meant to be ever-expanding and accessible. That principle that society has an interest in the free flow of ideas, information, and commerce is fundamental. The public domain has always been a vital source for creativity and innovation, and with the advent of the Internet, it is now more important than ever. The free flow of information and ideas is at the core of American ingenuity, and the emergence of digital technology empowers more and more of us to become creators in our own right. By protecting and advancing the free flow of information, we can nurture opportunity and maximize the progress of science, the furthering of discovery, and the growth of the American economy. Thank you for honoring the work of this brilliant and passionate advocate, and thank you all for the work you do to ensure and advance the freedom of information in our society. And the award? Thank you. Aaron Schwartz's family members could not make it to today's event, so I am now accepting this award on behalf of the family. His father told us that he was pleased to hear that his son would receive this prestigious award, so we will gladly send the award to his family. And I also want to thank Congressman Lofgren for contributing to making sure that this award would be here, and I thank all of you for attending the Madison Award event. Thank you very much.
Well, Patrice, thank you, President Sullivan, very much. Thank you. While Patrice makes her way to the podium, we're now going to move into a series of panel discussions, or actually presentations, in which there is a presenter and respondent, sometimes two presenters, sometimes two respondents. After each of these presentations, we will have a moment for Q&A with those of you here, because we view you as members of the panel in all cases and all presentations. So I'll try to move things along as best we can according to the agenda, but we'll see how it goes. We decided on this format a few months ago so that we would perhaps break from the typical panel kinds of presentations. So we'll ask everybody's assistance in making it work. We'll see how it goes. And with that, Patrice McDermott.
I'm back. Good morning. So, as Jean said, this morning's discussions are going to be looking forward toward what the Obama administration can yet accomplish in this second term that we've just begun. And we believe that is quite a bit. But I first want to spend a couple of minutes looking at where we started, how far we have come, or not, and at where the sticking points seem to be. Every year in early September, OpenTheGovernment.org issues our annual secrecy report. We used to call it secrecy report card. I'm sorry, I've got light right in my eye. So, but we really don't grade any administration, so we've just started calling it our secrecy report. We began doing this report at the height, or better, the depth of the Bush administration, starting in 2006. If one really wanted to take a look back, those years would be the place to start. Recently, I was looking through a book I wrote in 2008 for a particular item, and in thumbing through it, was reminded what a catalog of access horrors that administration was. So when President Obama said he was going to have the most transparent administration in our history, he was starting from a base of deeply undermined access, virtually no accountability, and a massive deficit of public and journalistic trust. Last year, we began our secrecy report with Donald Rumsfeld's famous musing. There are known knowns. These are things we know that we know. There are known unknowns. That is to say, there are things that we know that we don't know. But there are also unknown unknowns. There are things we don't know we don't know. His comment, we decided, pretty accurately assesses our problems in measuring, much less evaluating, the extent of secrecy and openness in the executive branch of the federal government. So what are our more or less known knowns during the Obama administration? Well, let's look at some of the government-wide numbers on FOIA. Over fiscal years, and those are the government years, 2009 through 2011, FOIA requests decreased, then increased. FOIA costs increased every year, and backlogs were reduced for 2 years and then grew dramatically. For classification and declassification, again for fiscal years 2009 through 2011, new classification decisions decreased, climbed significantly, and then climbed dramatically. For declassification, outside the efforts of the National Declassification Center, the numbers decreased, increased slightly, and then decreased again. So maybe what we think we know are more known unknowns. It's not really clear, especially on FOIA, why they vary, sometimes quite dramatically. So as useful as statistics and other data can sometimes be, they often do not get us all that far in answering questions about both perception and real changes in policy. We all know what we hear as perception about progress in this administration toward open government: empty rhetoric, broken promises, etc. There is a lot of frustration out there, fueled by the early statements of President Obama and Attorney General Holder, by our own desire to see substantive change from the dark years of the previous administration, and by our optimism. Some might say idealism or naivete. There is also real anger about the apparent wall between areas that are designated as national security and the President's commitment of his administration to maximal openness and to accountability. As the title of these remarks says, we want open government, and we want it now, or even better, yesterday. I will wager that the White House is also very frustrated. Despite very good policy statements in the form of directives, memoranda, and executive orders, change has been slow, even halting. Instead of a how high response from the agencies to the mandates from the White House, the response often seems more ho-hum. And when are you going away? The administration has had greater success in moving toward the goal of open government when it has required the agencies to make public commitments, to take specific steps, such as in the open government plans required by the 2009 Open Government Directive, and when it has itself made these public commitments, as in the 2011 National Action Plan as part of the Open Government Partnership. You can read about the agency's open government plans and the openness community's evaluation of them on our website, which is easy. It's openthegovernment.org. I'm not going to go into them here, except to say that a fair number of agencies have made real progress toward greater openness for accountability, using them as a starting point. And actually, we will hear from one of those agencies, at least one of those agencies today. One of our speakers from GSA, Martha Pazuka, is going to talk about some of the strides that they have taken. And if you want some good examples of what and where such progress is happening, I recommend that you look at a report that POGO put out on March 7th, highlighting best practices for open and accountable government. There is a handout available on the table back there as you came in with more information. Check out our secrecy reports for information about other areas where the President has taken significant steps to make more previously classified information publicly available, and for ongoing information about the progress and regrettably regress in this area, particularly national security information. Check out Steve Aftergood's Secrecy News. If you don't subscribe to that already, I highly recommend it. It's our go-to source. I do want to spend a few minutes, though, talking about the commitments the administration made during its 2011 in its National Action Plan. President Obama first presented the U.S.'s commitments at the launch of the Open Government Partnership on September 20th, 2011. The Open Government Partnership is a multinational, multilateral partnership working to make governments more accountable to their publics. And it has grown into a vibrant mix of governments, civil society organizations, academics, and others. Those engaged in the OGP experiment are all focused on making participating governments more open, more collaborative with civil society, what in the U.S. we tend to call nonprofits, and participative for the public. These goals are expressed in each country's national action plan, and each participating country is required, among other things, to consult with civil society organizations and to deliver a plan that includes concrete commitments. The U.S. released the first National Action Plan to coincide with the announcement of the launch of the OGP. It addressed three broad challenges: to increase public integrity, manage public resources effectively, and improve public services, and included 26 concrete commitments to help achieve 17 larger goals. The 17 goals really are noteworthy and are a clear sign that the administration understands most of the broad range of issues that must be tackled before we can achieve the greater goal of transforming government to be open and accountable to the public. The plan did not, however, address several critical issues, notably those surrounding national security secrecy and what we are calling secret law, the OLC memos, the FISA court opinions, the Electronic Communications Privacy Court opinions. There's this growing body of material that affects and determines our lives that we can't know anything about. We're not allowed to know anything about it. So we will be pushing them on those. The specific commitments in the plan address areas of concern for a broad array of stakeholders and address many of the topics that will be discussed this morning, and reflect a number of our community's policy goals. Our goals are incorporated in 8 policy priorities as specific recommendations for improving and strengthening federal government openness. These are goals that more than 20 national organizations committed to improving openness and accountability have discussed together since 2011. So at least in our smallish community, they have a broad base of support. The administration has taken action, actually, related to 3 of these priorities: proactively disseminating accountability information, improving ethics disclosure, and ensuring responsible use of the state secrets privilege. Taken steps. These priorities and recommendations were again shared with the government, our 8, as the first plan that I mentioned was being developed. And the first National Action Plan included goals and commitments that reflected 5 of our 8. Improving administration of the Freedom of Information Act, transforming national security classification, protecting whistleblowers, improving disclosure of the government regulatory process, and improving disclosure of information about government spending. My organization worked with 37 other organizations on an evaluation of the government's commitments and its implementation of them, and we just this Tuesday released a plan, another handout back on the table, of the government's efforts to meet the commitments in this first plan. It shows that the government made progress on most of its specific commitments. The U.S. responsibilities under OGP, though, are far from finished. The administration must soon and is beginning to develop a roadmap for its second National Action Plan. So while we are gratified at the steps that have been taken, as I mentioned, we will be pushing to expand the government's reach on these issues that it has addressed and to get movement on other issues, including, again, secret law and profound concerns that the community in general has and the public has surrounding national security accountability. We invite all of you to join us in working for open and accountable government now and over the next several years through the second term of the Obama administration. So I thank you, and now I'm going to move us on to the program for the morning. Each discussion is framed around one of the 5 policy priorities just mentioned, those ones that were included actually in the plan, where we have made progress and believe real possibilities, real opportunities exist for more and better. Each discussion includes a person from the OpenTheGovernment.org coalition and a current or recently former government official, and as Jean noted, with times for questions from you and from our remote audience. And we will be, you can send questions via Twitter at OpenTheGov, or you can send them through email at questions@openthegovernment.org, and that information will be up regularly through this morning's discussion. So thank you again for coming. Thank you for your attention, and we will welcome your questions once our discussants have finished discussing. Thank you.
Well, we invite the first group. We invite the first group to come to the stage, if you would. And in the process of, as we move through, very good. We're moving through, I'd like to welcome those of you watching us via live stream. And as Patrice mentioned, you may send your questions throughout the day at OpenTheGov via Twitter or questions@openthegovernment.org. All right, and we're miking our folks. And so I guess this is the appropriate time to say, since we are live streaming, that if you would join me, and I believe I have, in shutting off cell phones for the moment, at least putting them on vibrate for that great moment when someone calls, or otherwise silencing those, and as I often feel prompted to do, anybody with a watch or a warrant, we are going to be live streaming, so you'll be seen around the country. Time to duck out the back door when you can. So we'll be moving along. I will actually have a very irritating stopwatch that I'll hold up on my iPad when we get there. We're going to try to move through the day. But there have been some internal negotiations in each of the groups on time, so that's fine with us. But again, the point here is to have a good, active discussion, have presenters and respondents, and then questions from you. So with that, I will get out of the way. And in the manner of things, since everybody here appears to have or access to a mobile device. We really don't do a great deal of introductions, but if you would introduce yourself as you begin your remarks, and then we'll let the cloud take care of the rest of the details. So thank you very much. And with that, we are underway. Thank you.
Good morning, everybody. I'm Ann Wiseman. I'm Chief Counsel at Citizens for Responsibility and Ethics in Washington, which is one of the partners of OpenTheGovernment.org. When Patrice asked me to be on this panel, I assumed I'd be giving my usual rant about the Obama administration and how woefully inadequate they have been and how they have failed us. And then when I started to look at the actual program, it was like, oh, I'm supposed to come up with positive recommendations. So I think, frankly, a reflection of the weariness I feel after all these years. My recommendations are probably, I think, fairly modest, but hopefully that means that they're doable. But I do start from the premise that there has been a significant disconnect between the policies and the actions that has led us to a great deal of frustration and some anger. My group uses the courts a lot, and that's a venue that has proved in some ways effective in making change. But even that's got limitations. The D.C. courts are just overburdened with FOIA cases, and they're very deferential to the government. So what are some steps, trying to put on my positive thinking hat, what are some steps that this administration could do and that there's still really time for? I think the first one is that agency regulations need to be updated. I think this is critical. As a FOIA requester, the first place I go to when I'm going to file a request is the agency regulations to look at what are my responsibilities, what are my reasonable expectations about what I can get. And I think for agency FOIA personnel as well, their regulations should be their talisman about what their responsibilities are. And yet, as a recent study that came out, that was released this week, an analysis by the National Security Archive showed, and I want to make sure I get the numbers right, 53 out of 100 agencies have not updated their regulations since the Open Government Act of 2007. 53, over 50% of agencies are operating with outdated regulations. And it was, I don't know how many of you either attended or watched the stream of the hearing before the Senate Judiciary Committee this week, but it was so disheartening to have the Justice Department's representative, Melanie Pastay, say that agencies don't need to update their regulations to comply with the amendments. What does that mean? It means that the amendments don't reflect the changes to media requester status, which I assume, like our group, is very important to many of you. It means that the regulations don't have the new tolling provision changes, which say, absent certain circumstances, if you don't comply in 20 days, you can't charge fees. It means that the regulations are silent about the existence of OGIS and what it can do, and any recommendations to agency personnel to use OGIS's services to resolve disputes. These are just some of the things that are completely missing from regulations in 53 agencies. And unfortunately, despite efforts by my group and others and OpenTheGovernment.org, OMB, which is the logical entity, I think, to direct agencies to update their regulations, has just refused to enter this arena. So I think that is a workable, reasonable first step that agencies can and should do. And I just have to give a shout out. I'm going to be pretty positive on OGIS this week, today. At that same hearing, when Miriam was asked the question, she said there is a strong interest in updating regulations. And she is absolutely correct. The second thing I think agencies need to do, they're starting to do, but there needs to be a more comprehensive effort, is to embrace new technology. And I think for many of us, the thing that probably offers the most promise, although it's still in its infancy, is FOIA Online. And I don't know how many of you are familiar with FOIA Online. It's the portal or module that the EPA developed and Commerce, with participation from NARA, developed. It's a one-stop shop for, you can submit your request and it will be fielded to the appropriate agency. The goal is at the end of it to have all the documents that agencies disclose will be available there. You can track the progress online. I mean, it's had a few hiccups, and it's in its very initial stages, but it is an extremely promising technology. So why am I bringing it up? Because despite this promise, the Justice Department and OMB have not supported it, and all indications are that the Justice Department has worked behind the scenes to actually block it, has talked to agencies, discouraging them from participating. And in Melanie Postay's testimony this week, she unveiled efforts that they're doing, which sound a lot like this. They're having some digital, what did she call it? A digital FOIA pilot program, and they're talking about implementing a government-wide FOIA library that would have all the FOIA documents that have been disclosed. Why would you spend the time and resources to develop something that's already developed? Why? I mean, the only thing I can think is that it's this kind of turf war going on that so disserves the public. So I think that the administration should get behind something like FOIA Online, and they should really push agencies as soon as their contracts with that they have with outside vendors for software expire to join it. I think they should recognize the tremendous potential that it offers. And I would note that Congressman Issa has a bill out there that would do two things. It would require OMB within 1 year to ensure the operation of a single website to submit requests to, and it would require OMB to establish a pilot program to evaluate the benefits of FOIA Online. My third recommendation, and in large part, again, this comes out of this week. Sunshine Week is a really interesting time. All of us are doing things, we're issuing reports, and so it really gives you a time to stop and say, what's been going on? Well, one of the things that has really struck me this week is that the data and the interpretation of the data is so widely varying. The National Security Archive came out with its assessment of compliance with regulations. The Associated Press came out with its report. Center on Effective Government, I think that's what they call themselves now, came out with this report. I mean, there were tremendous numbers of reports. And then we had the Justice Department and their congressional testimony this week, which, relying on the same statistics, the same numbers, said, things couldn't be better. It's the rosiest of pictures. And this really does a disservice to us, but also to Congress. I mean, the Open Government Act amendments, added all these provisions that required the Justice Department to accumulate and post all this data and evaluate. For a reason, because the data, I mean, I agree with Patrice's remarks that it only tells part of the story, but it's still a useful tool to be able to assess how is the FOIA working. Oh, am I being flagged? All right, so I'd
like to introduce myself, soon to be the most
yes, so I think there needs to be a neutral interpreter, and my recommendation would be OGIS, because I think they've shown themselves to be a neutral player. And I just want to put out one more thing. The simplest of things can make a difference, and that is the administration should be using its bully pulpit. And if you want to know what I'm talking about, take a look at the letter that David Ferriero, the archivist, just issued to all employees. Talks about how FOIA matters. Take a look at OGIS's report they issued yesterday, which talks about FOIA matters and all the articles, for example, that have come out that relied on the FOIA. I mean, why don't we have the Justice Department giving us examples of FOIA matters because this kind of information gets in the public domain. So I will shut up. I'm sorry I used more time, but I'm a litigator, so that's how I work. And I'll turn it over to Miriam.
Supreme Court, I believe they say you're invited to conclude your
Yes.
You were just fine. You were right on time. So I'll do that sort of flag about a minute before time is up. The next presenter, please.
Thank you, Jean. I think we're sort of going in this order. We also negotiated a little bit on the seating arrangements, as you can see. So it's all working out just fine. Good morning, everybody. My name is Miriam Nisbet. I'm Director of the Office of Government Information Services, OGIS, as we're affectionately called, I think affectionately. We're part of the National Archives and Records Administration, and really the new kid on the block in the FOIA world. And it is wonderful to be here amongst so many people who care so deeply, so passionately, and advocate so strongly for freedom of information, which is what we're all about. I've been told I have about 5 minutes. I'm going to make 5 points, and I can do them pretty quickly because 2 of my points are going to really echo what Ann has just talked about. FOIA regulations, very important. Updating them, getting them into plain language so that they're better understandable by requesters and by the agencies themselves, I might add, we think is very, very important. Our office, when it was set up, was given a twofold mission. We, for the first time, are part of the process of bringing mediation, dispute resolution into the FOIA process administratively. And we also are charged with reviewing agencies' policies, procedures, and compliance. We're a small staff. I think a lot of you know that we are 7 people. It's important for us to rely upon organizations like yours, and National Security Archive this week to assess and see where things are, because we really depend upon everybody's reporting to help us see policies, procedures, and compliance. But one of the things that we do regularly, religiously, is to look at proposed agency revisions to their FOIA regulations and comment on them every single time, because we do think that's an important way that agencies need to be implementing the law. The second thing is, as Ann mentioned, the National Archives and Records Administration is one of the founding partners, along with the Environmental Protection Agency and the Department of Commerce, for FOIA Online, the new multi-agency portal, and we think it holds a lot of promise. Technology, there's not just one way to do things. The beauty of the world we live in today is there are a lot of people looking at a lot of different ways to improve things, and we're all for that. But we do hope that other agencies will join FOIA Online. We think it holds a lot of promise. And it's working, and by the way, the partners who participate, there are 6 of us now, are finding it works great. We're really happy with it. Ann mentioned the OGIS report. It is available. It's online as of last night, but we'll be sending the links to everybody. We have a report. We also issued recommendations that went to Congress on Wednesday. Those also are going to be available today, and I want to talk a little bit about those. We're looking at several things in the coming year, 2 years. One area that we think is really ripe for a new conversation is fees and fee waivers. It remains a persistent area of confusion and difficulty for agencies and for requesters, and we really want to bring everybody together and start talking about, are there any changes needed in the law or administratively, or are there just some is there some consensus around maybe some solution to the fees and fee waivers? Another area that we want to look at is immigration-related records. Again, not so much with an idea that maybe the FOIA itself needs to change, but the FOIA is the path for people who are not U.S. citizens and not permanent resident, legal permanent residents. That means that FOIA is, for the most part, their path to finding access to records related to whether it's deportation, visas, asylum, and again, we think that's a really good place to look at how we might improve the process. So I've mentioned regs for you online, fees, immigration records, and the fifth point is dispute resolution. I'm simply going to say, and I think everybody can agree, even those who litigate would say, well, we have too many lawsuits over access to government records. We think there's a better way. We would like to see dispute resolution, and this is one of our recommendations, really embedded in the administrative process so that these disputes are prevented or resolved. They never have to get to the court. So that's 5 points. I am going to mention one thing just as a preview. You're going to have a panel talk about national security. We hope, if you haven't read it, that you will read the report of the Public Interest Declassification Board. Really excellent and really pushes for changes that need to be made. Thank you.
Thank you, Miriam. My name is Danielle Bryan. I'm the Executive Director of the Project on Government Oversight. I'm also the Chair of the Steering Committee of OpenTheGovernment.org. And I realize it's a pleasure to be on an all-women panel, which doesn't happen very often in Washington. Yeah. That's kind of neat. So what we've been talking about so far has been the Freedom of Information Act, its application and implementation, and that's, of course, maybe the most important open government law there is. But remember, that is about fighting to get information that isn't already public. And our community took a step, really, it was probably several years ago that we started this process, and thinking, there are universes of information that we should not have to file Freedom of Information Act requests to get. They should be proactively always available by agencies, put up so that everyone can get them without having to ask for them. And so our community worked around, okay, of course you can imagine with all of the cats in our universe, there are 600 universes of information we all thought should be proactively available. But we finally got ourselves together down to 6 kinds of information we thought that would best help us understand the operations of agencies and their decision making, and that really should not be a problem in agencies making them proactively available. We call them the minimum standards of open government. And similar to the point Ann made earlier, in many of these cases, the president or some White House blog writer has made the point that these things should happen. So the idea has already been out there. It's a case of the agencies not actually doing it. And so I'm going to go through the 6 areas that we concluded really should be publicly available. And as Patrice had mentioned, actually, we collected a number of examples where agencies are already doing it on their own. It's just that we have, what is it, 73 agencies, 60-something?
99.
Okay, lots of agencies. So they keep growing. So this is the problem, is getting all of the agencies to do it. The first one is communications with Congress. Now, Congress, of course, puts testimony up for the most part on their websites, but you don't have a place at the agencies in many cases where they're putting up their own testimony, their reports to Congress. But also what we find would be really helpful, and the agencies, frankly, would probably find it helpful if they'd have the guts to start doing it, is those letters from Congress to the agencies. Often what we call them is letter marking, sort of telling the agencies how they want to do things. That is the kind of information we think should absolutely be proactively put up on all the agency websites. Some of the agencies are starting to do this. The FAA is posting agency reports. EPA is posting congressional testimony. But and in fact, the executive order, there was an executive order that did require all these communications that I refer to as letter marking, which is kind of earmarking, but it's sort of Congress telling the agencies how to do it. But we're not seeing examples of that happening, despite the fact that the White House did issue this executive order. That's the first one, communications with the Congress. The second is what we were talking about before with Freedom of Information Act requests. Remember that for many years, I would file a FOIA request from POGO, and then our colleagues at CREW would then also file the same FOIA request because they didn't know that we had filed it, because it wasn't then made public once it had gone through the process. There is a process now that is supposed to be implemented but is weekly implemented that says if there's something that's obviously of interest and more than a couple of people have asked for it, agencies are supposed to start putting it online. But the idea is once it has gone through the process and has been redacted for privacy or other considerations, why isn't that then automatically put up so other people know it's out there and it doesn't have to go through the process again? It's sort of an efficiency question. So that was the second one, that of course the FOIA online portal would be a fantastic way of just streamlining all of that. And so we agree that that's a centrally important advancement. The third one is agency visitor logs. This is something that I found really funny. Our colleagues at Crew were successful through litigation in forcing the White House to make public their visitors logs. And since that time, the White House brags about that all the time. It's one of their great achievements. It's sort of funny.
Out of the goodness of their hearts.
Yes. But so we were saying, well, actually finding out who is going into the agencies, because, you know, there's the theory of lobbying, of course, is happening on the Hill, but a lot of it is going on at the agency level. Who's going in to talk to our regulatory agencies, and who are those visitors? And so when we began pressing this issue with some of our contacts at the White House and OMB, they were saying, oh, that's so burdensome to have these visitors logs put online. And so because all of us are going to the agencies all the time, we said, you know, actually, when I go to the agency, it's already in a computer. You know, I mean, how many of you go to an agency and you have had to make an appointment and you know that they check your name on a computer? Already it is electronically created. And so that is something that we see as something that is so clearly simple for those agencies that already have an electronic visitors log. And we were happy to discover, and we'll be hearing from our colleague, that GSA already is putting their visitors logs online. So the idea is, well, why if the GSA can do it, can't most of the agencies? We understand we're not yet trying to get the CIA visitors logs, but, you know, let's start with some of the more basic ones to understand who is going in and out of these agencies.
Danielle, it's not that easy to get in.
The next one is employee directories and contact information. This was another one that I was surprised at how much pushback we got. Oh, there needs to be anonymity of the government employees, which really is sort of a problematic concept, right? And then we discovered the State Department puts their employee directory and their phone numbers online. So it sort of undermines the theory that agencies that are nowhere near having the kinds of possible complexities that they might with interacting with the public can't put theirs online. So try to find someone in the Justice Department through their website and find their phone number. It's not very easy, let me tell you. Another one is calendars of top officials. This is an example where we have, for example, the Consumer Federal Protection Bureau, Financial Protection Bureau, has put their calendar of their leadership online every day. Others, USDA, Food Safety Inspection Service, has their calendar of official meetings. GSA is going to talk about some of the ways that they have done that. This is a good way of knowing what are our leaders of our agencies. And we actually think not just the heads, whoops, sorry, I'm throwing things, not just the heads of the agencies, but the heads of the departments. Whoops, I'm going over too. We have so much to talk about. We think it's a really essential way of getting an understanding of what is happening within the agencies. And the last one is Federal Advisory Committee's information, and knowing, you know, these are outsiders who are either representatives or special government employees who we need to understand what are their, who are they representing, what kind of advice are they giving to the government, and there are laws, the FACA law actually has some requirements for disclosure, but getting them open to the public so that everyone can see them is something that most of the agencies are not yet doing. But I'm going to turn it over to my colleague Martha at GSA because they are actually implementing a lot of what we're talking about.
Yes. Thank you so much, Danielle. And we're very pleased to be asked to participate in FOI Day and Sunshine Week. And Danielle said we wanted GSA here because they do practice good open government. So I'll be covering a couple of those today. And go ahead and get the next slide. The three pillars, core pillars of open government that President Obama established are the collaboration, participation, and transparency. And this morning I'll cover primarily transparency and our proactive disclosure. By the way, I am with a different OGP than Patrice mentioned. I'm with the Office of Government-Wide Policy within GSA. We are a policy-making organization, and those three pillars are very critical to us providing timely, smart, and relevant policies.
Congressional testimony. It is posted a day of, earlier this week. Dr. Dorothy Robine of our Public Building Services, our commissioner there, she testified on the Hill. And the reason I know it went up just hours after her testimony is our front office tweeted it out. They tweeted it out with a link. We use social media quite a bit to communicate with our stakeholders, our customers, and the citizens. Our staff directory. Very easy to find any of us, and it's our name, typically our title, our email, and our phone number. If you look me up, you will have my work cell number. It's the staff directory you find on our public-facing website, gsa.gov. It's very similar in functionality to what we have internally. It's the same information, and I don't see a reason why other agencies could not do that as well. Additionally, on our public-facing pages, on almost every one, you'll see in the right-hand corner, this is part of our content management system, there is a contact block, and that typically has, again, that director, office director's name, email, and phone number, or a group email account, and I manage several of these for OGP. For example, Ask Acquisition at gsa.gov. It's monitored by 4 individuals who are very responsive, and they learn from every inquiry. Agency reports, they're across the board. There's one central area where you can find budget, performance, our sustainability annual report, our open government report, but we have increased our search functionality, and just about any report that you would want, I would almost guarantee that it's going to be there. And they're very timely. If it's not day of, it's the next day. FOIA, I'm not going to talk a lot about FOIA, except that when we receive a FOIA request in my office, my associate administrator makes it our #1 priority. We are told there is a strict deadline. There are other internal reviews that need to be done. So it is processed timely through our office, and I love the FOIA online system that Miriam has referenced. I know we have our own internal system, and we have recently added additional functionality with some innovative technologies to streamline the processing internally and the coordination and collaboration across GSA to release that information. Next slide, please. The FACA, the Federal Advisory Committee Act. GSA has had the responsibility for overseeing the FACA since 1977. Today, an average of 1,000 committees with over 60,000 members advise the President and the executive branch on complex issues across the government. Each federal agency sponsors their federal advisory committees, and they must adhere to the requirements established by FACA as well as the GSA Committee Management Secretariat. This page, and I hope you'll take a look at this, there's a back-end database. There are drop-down boxes. You can select your agency, select the year for those committees, and in this case, I selected Department of Energy because they tackle very complex scientific issues, and selected the Advanced Scientific Computing Advisory Committee. Next slide. And you will see it takes you to a page within Department of Energy and that FACA committee. So it's everything you want to know about exascale computing, and it has the meeting date and time, location. It has relevant contact information, emails and phone numbers, the charters, and I'm sure there are meeting minutes more than you'd want to know. And this is important because you want to know who are those subject matter experts on this exascale committee. So I thought this was a good example of the FACA compliance. Next slide. GSA visitor logs. Yes, I'm always dismayed when I go into another agency and I'm asked to sign a paper log. And it's like, you know, why we have the technology to have this digital. And typically I know when I have visitors, I just send it digitally to our security department. So GSA does provide our visitor logs in electronic format. We actually provide two logs, one for 1800F, our original location, which is under construction to make it a green building more sustainable, and our swing space in NOMA. And we post these each month. I also wanted to show you the White House log. I was very pleased to see this. The White House has it electronically, but they've also developed an API, and I'll talk a little bit more about this. It's a software program that allows you easy access to this data. Next slide. I'm sorry, go one slide more with the bubble chart. Yes, this is from 2010. Our friends at Fierce Government IT developed this not through an API, through mashing and combining data to make it just more visually pleasing. And it was a visitor log for Vivek Kundra, the CIO at the time. And I hope I will talk to their publisher, see if they'll do another one with the recent logs. Go one back to per diem. And boy, I better hurry up. This is the per diem, which establishes the rates for lodging and meals across the United States. This is done within the Office of Government-Wide Policy. And these are posted on our gsa.gov site. Per diem is the #1 reason that visitors come to our public-facing website. And because we want to be more responsive to our customers, we have made this information available not only in flat files, downloadable in Excel, but also as a mobile application on 3 different mobile platforms. Additionally, we recently created an API so that these developers and programmers can take the data off of data.gov and bring it into other applications. And additionally, I just talked briefly about public participation. Again, being a policy-making shop, we collect a lot of data from the agencies, and it's our job to analyze that data to make, again, smart and timely, very relevant policies to the federal agencies to encourage to drive more efficiency in the administration. So transparency and accountability is very important to our office. And we provide the data, the reports, the open data on our public-facing website, and additionally on data.gov. And we hope there'll be more application programming interface, APIs built so that the citizens and our customers can more effectively use this data. So in closing, I think GSA has done a good job of proactive disclosure, and we also have the infrastructure and the culture to drive open government success. Thank you.
Thank you to all of our presenters and respondents. We'll now go into Q&A for the group that is on at the moment. And I would invite you to approach the microphone, which is on a stand here. And if you would line up there, we'll try to get through as many questions as we can. Again, the reason we're adhering to time restraints is just to be respectful of your time and those of all the presenters. So I apologize for that irritating stopwatch. I'm trying to make it as advisory as possible, but we have a lot to cover today. And we'll go to first question here. And if you would just tell us, if you would, who you are and some manner of identification, agency or whatever, it's fine. Thank you.
I'm Amy Bennett, and I'm with openthegovernment.org, but I have a question from our Twitter audience. So the question is, Anne, you said that the courts are giving deference to the government's litigators. Can you tell us a little bit more about why that is and what sort of problems it creates for people who want public access?
Well, I think we see it the most in issues of national security, what we call Exemption 1 claims. Exemption 1 is the FOIA exemption that allows the government to withhold classified information. I just think that there's a growing trend among judges not to want to interfere, and I really think it started to especially increase post 9/11. You know, as a nation, we were really grappling with this whole issue of how do we balance, First Amendment and national security interests. And I think it's become the default. I think the judges, we have a more conservative bench, thanks in large part to the large number of judges that were seated during the Bush administration. And I think it's just the course of easiest resistance.
Hi, I'm Kevin Goldberg. I'm an attorney for the American Society of News Editors. And I have a question for Martha, more of a clarification. You mentioned that you get, maybe I'm using the wrong word, pressure to respond to FOIA requests quickly, or there's definitely an emphasis put on it. Where does that come from? Because that's one of the things I'm really interested in is you also use the word culture. How is that culture created within your agency? Is it from the chief FOIA officer, the FOIA liaison, somewhere else?
It's from my boss.
That's the best place, I think.
It really
the higher
is.
up that pressure comes from, the better.
It's because we want to make sure that we're responding in a timely manner, and we have to search across all sources, so we want to make sure we're inclusive.
Well, then could you clarify just a little more, apologies, what sort of forms does that take, and what happens if after the first request it's not being done? Like, how do they keep things rolling, I guess?
We deliver on time, so I haven't had that happen.
My name is Li Yang. I involve a lot of civic activities, and I appreciate this panelists cover a lot of areas. But the problem is one step forward, two steps backward. So our society is getting worse and worse, and social justice is in great danger. I just wonder if you really get into the problem, for instance, processing of complaints. They don't really processing. They drag a complainant for decades, and they don't even reimburse the legal fee, even you won the case. And then, you know, when you say open and when you say transparency, but your request of information, even your personal information, they don't really, according to your request, they rewrite your request. And this including almost every agency from local to federal. So I just say if you can really follow that up, see who is really disobey their own regulation or rules, and we really have to punish those. Unless we have a good implementation, then there's no hope. Everything is rhetoric.
And your question is?
My question is if you really can follow up your effort to follow those implementation or complaints or a request, whether you really follow up all those requests and implement it right.
Thank you. I think it's essentially the idea of following up on what appears to be the failure to respond to an FOIA request. What policing kinds of activities are in place or might be in place, if I can summarize the question.
May I try that? Lack of a timely response, or responses that say you're asking for too much, or we don't understand what you're asking for, so we're not going to consider your response a good one. That does remain a problem, and it remains a problem at some agencies more than others. There are now several things in place in the law, thanks to the 2007 amendments, to emphasize that there is responsibility to respond to that. Each agency has a FOIA public liaison who's the first person that should be available to talk with a requester, to give the status of a request, to talk about the scope of the request, and to assist in resolving disputes. There is also my office, the Office of Government Information Services. If you have a problem, if you do not feel like the agency is being responsive to you, please come to us and let us try and help. That doesn't mean we can always make a difference. Certainly we can't always make a difference, but we can give it a good try.
Can I just add to that? I think one of the critical pieces of the whole FOIA process is communication. Some agencies do a terrific job, and I get calls and we have detailed discussion about what they have and what I want, and we all get on the same page. Other agencies, I can't even get a phone number or the name of a person. So I think this continues to be an area where agencies need to improve, and they need to stop being afraid to talk to requesters.
We'll go to our next question, but would I ask if you could formulate your question quickly, because we do have a number of people and, again, a limited amount of time. So thank you.
I'm Charles Pico, a freelance journalist, and I wondered, does anybody know if the sequester is or may be used anywhere to cut the resources available to respond to FOIA requests?
Well, okay, I'm going to take a shot at that. Every agency has its own plan for dealing with the cuts. I know in my parent agency, the National Archives and Records Administration, they're trying very hard to take a number of steps that will not require furloughs. That would be furloughs across the board, regardless of what your job is. So every single program, whether it's FOIA or whether it's preservation or declassification of national security classified records, or shortening the hours that the public can come in to see the precious documents that we have, across the board, they're going to be cuts. Every agency is doing it a little bit differently, but it's hard for me to believe that it's not going to have its effect. That's a service like everything else.
A different way to answer your question is I don't see any evidence that there's anything protecting the FOIA process from those cuts. Right?
No.
Hi, good morning. David Kruger. I'm Vice President of AINS. We're the purveyor of FOIA Express. And Gene, at the beginning of the conference this morning, you invited us to a vigorous conversation, and I would just like to make a couple comments. So James Madison's neighbor down in Charlottesville, President Thomas Jefferson, said, "In matters of style, swim with the current. In matters of principle, stand like a rock." So my company's been a champion for citizen rights and open government for 12 years. When we first released FOIA Express 12 years ago, we're now getting ready to release version 9. Over the years, we have added thousands of enhancements. We have saved the government tens of thousands of hours in the production of the annual FOIA report. We rescued the Air Force from a multi-million-dollar judgment when they deployed our software. So, Ms. Weissman, it hurts me, or I would just like to echo your words, that why would you go spend time and resources to build something that's already developed? Our software is a proven, well-established solution for receiving, processing, managing, and reporting on FOIA requests in the federal government. So it seems odd and perplexing that the government would choose to compete against the commercial sector when OMB Circular 876 cautions against this type of behavior. So and Ms. Nesbitt, you also talked about the importance of baking in the idea of mediation into the process. Well, our new advanced document review module actually gives the federal government the ability to track and record how search is conducted. As you know, Judge Shira Scheinlin has wrapped the government's inability to document searches, and that's why so many cases end up in litigation. So it is my hope that with the same skepticism that the FOIA professionals engage the government in terms of its commitment to openness, is that the embrace for the government's own development of a commercially available system, that we when it comes time to actually move to a government-wide implementation, that it goes to a free and open competition, and it's not done something behind closed doors without competition, because as of now, FOIA Online was developed without competition and has spent precious resources for a product that already exists in the commercial market space. Thank you.
All right. I'm reminded that the First Amendment protects commercial speech as well as open speech. But I think a point about competition in delivery services is a good one. But again, moving to the next question.
Okay. Not a question. My name is Michael Binder. I'm with the Air Force Declassification Office, but I'm not here speaking for the government. We in declassification have a lot to do. Every time I come to a meeting like this, though, I just hear about all our failures. We have to do FOIA, MDR, security reviews, manuscript reviews. We're asked to review the President's executive order. We're asked to review a modified regulation for FOIA, both for the Air Force and for the Department of Defense. We're asked to do a declassification guide as required by the new executive order. We're asked to do training for our own people, for other agency people. We're asked to travel to Air Force installations to do briefings. But all I hear is that you're not doing enough. You're not doing enough FOIA reviews. You're falling behind on the MDR. And I'd just like to hear a little bit more positive about what we're doing, about the cases that we do close, about the information we do provide, about the proactive disclosures we do make. It's very easy to say that we failed because we will never eliminate the backlog. It is not in our power. The requesters control the backlog. When somebody makes a request for 20 years of histories of 3 major Air Force commands, this is going to be 50,000 pages. It's all classified. It's going to have to go out to many different agencies for review. We can't control that backlog. That is controlled by requesters. So I just ask for a little understanding and a little recognition for what we do accomplish. Thank you.
I'd like to, please. First of all, I'd like to make the point. First of all, we do have 2 representatives of government agencies who are talking about we were acknowledging the positive contributions that they're making. And I'd encourage you to realize that part of why we care so much is because we think the work you're doing is so good, we want more of it. We want more of you. We're fighting to get more resources for your offices so that you will be able to handle the backlogs. We recognize that your role is incredibly important to our democracy.
And the reason, for example, that we embrace technology is because we know you're short-staffed. We know there aren't more resources there for you. We are trying to encourage the government to move in a direction where it doesn't have to depend on one person to do all of these tasks. So what we're not up here to criticize today. We're up here to give some ideas on how to improve the system for all of us.
And if I may, one of the things that I said in my testimony before the Senate Judiciary Committee on Wednesday was one of the things that we feel like in our office that's important to do is to help requesters understand just how difficult and complex it is for FOIA professionals to do their job, sometimes particularly with voluminous records, with classified records. It is a very long, painstaking process, and we really want to help everybody on either, whether requester or agency, understand each other's issues and problems.
We have time for one more question.
Okay, 2 quick questions. First for Martha.
Just to make me feel better, would you call that a 2-part one question?
Okay. So in your presentation at FACA, you said you'd focus on transparency. My question relates to public participation in FACA. There's wide variation in the allowance for public participation with federal advisory bodies from no participation allowed to under highly restricted circumstances. Should these policies be disclosed, and should there be, like with a typical local public meeting, this open public participation component, should that be allowed or incorporated into the FACA process and the information that you provide? And then I have a second quick question related to FACA also.
So that one page that I showed you about the agency FACA committees, it's really up to the agencies to post that information, and in most cases you will find their meeting information way before the meeting.
Which is a public participation, the public participation
Yes.
component. Okay.
Yes.
Well, the law requires that they have to notify prior to the meeting where it will be held.
But that's
Right.
different than actually being able to raise issues at the meeting. Okay. So the next question for Danielle and Ann is the intersection of FACA, FOIA, and ethics disclosure. So the ethics forms are not covered under FOIA in relation to FACA, and there are gross abuses in ethics disclosure regarding FACA in terms of not doing it, seeking blanket waivers, not disclosing anything online. So the first question is, should the ethics process, say the blanket waivers, be disclosed online, including the conflicts of interest, which are often blatant? I think the agencies are abusing this quite a bit with all these blanket disclosures and nobody knows what's going on, who these people are, where they're coming from. This is a really obscure part of FACA. So, in other words, should it be incorporated? Ethics disclosure as part of the FOIA process, because currently they're separate processes, and it allows actually for an additional level of unaccountability. However bad FOIA is, ethics disclosure is arguably even worse.
I can start on this one at least. I would argue it should have nothing to do with FOIA because it should be proactively disclosed. If you're dealing with a FACA committee, I believe all of these things should be absolutely proactively disclosed on the agency's websites. We did note, for example, that the FDA, which has lots of advisory committees that matter greatly for recommendations on whether drugs and medical devices should be approved or not, while they do disclose already the waivers, our concern is that the decision on whether a person requires a waiver, almost everyone on FDA committees have conflicts that we think that, have some relevance, but it's internal to the FDA where they decide whether or not it requires a waiver, and it's only then that they be disclosed. We think there needs to be far more disclosure on what's going on, and there isn't yet. But I don't think it should be relying on FOIA. I think it should be proactively disclosed.
Yeah, in the ideal world, yeah.
I certainly agree with that.
Please join me in thanking our panelists and respondents.